I don't know if we're the soundbite panel,
Yeah.
but as you can see from the name, Beyond the Ivory Tower, I think the goal here is to broaden the discussion beyond what's going on in the academy and take in some other similar kinds of conversations that are going on with different audiences around the country. What struck me, and I'm a lawyer, not an academic, is as the last day and a half has demonstrated, there's a very vigorous debate on this issue of how to interpret the Constitution within the academy, but not much of that has filtered out into, I hate to use this expression, the real world. Outside, it's quite different. I think the sound bites that one hears are legislating from the bench versus strict constructionism, judicial activism, and personal predilections of judges ruling the day versus some very strict limits on what judges can do. And unfortunately, couched in that way, the debate is not particularly positive for our side. So I think what we're going to try to do today is talk a little bit about that debate and how to translate some of the very good ideas that have been talked about today into influencing that debate that's going on around the country. And we have a great panel because we have some people that are mostly in the academy but have one foot out, and then we have some other people that are mostly out of the academy and have one foot in. So hopefully we can put together all the viewpoints here. And the way we're going to do this is in a series of questions. Sorry, we don't have any papers to present. And I think that the first thing we'd like to talk about is who are conservatives reaching? Who's talking about this issue outside the academy? In sort of public policy terms, that would be who are the audiences? Why are conservatives successful in the message that they're putting out? Because although it may be that originalism isn't on the lips of everybody in Joe's bar, I think if you talk to elites and people who actually are not in the academy but talk about constitutional interpretation, originalism will be the first thing that comes to their mind as an approach and a way to do it. And why have they been successful in doing that? And finally, why do we care? Maybe it doesn't make any difference what's happening in the outside world. So I don't know, Melody, you want to kick off?
Oh, okay, sure. Well, first of all, thank you so much for having me here today. It's a pleasure. As I told Lisa and Mir when they invited me, I've never been to Nashville, so it's like when you were little and you used to put pins in the map of the places you hadn't been before, so it's good to be here. One of the things that I was thinking about, I was recently reading or rereading Profiles in Courage and before I left in the seat pocket of the plane, and so who knows where it is today. But one of the things that struck me in reading it, and you read about Daniel Webster and Sam Calhoun and others, was when there were these great debates that took place in the Capitol, that people got on their horses and they walked and in their buggies, and they packed themselves into the gallery to watch what was going on the floor of the Senate or the floor of the House. And you get the sense in reading it that there's this great reverence. That it was hot and sticky and sweaty, and people were hanging over the railings and really kind of hanging on to every word that was being spoken. And it strikes me that though people poo-poo our ability to do this, that we need to get back to some sense of that with regard, or get to some sense of that with regard to people paying attention to the courts, to constitutional interpretation, to what's happening. Because clearly people are being affected by it, and what they're thinking about what's going on with the courts and with constitutional interpretation is not good. I mean, if you look at some of the polling that's out there, some of the research that's being done, you know, it's 47% of the people as compared to 44% think that the courts are out of step with the American people. There's a 2006 ABA poll that was done. 56% say judicial activism seems to have reached a crisis level. And I think, going to Andy's question, that in large part that's due to the success of the conservative movement making this a populist issue. I understand, I got here late, but I understand that Bill spoke to some of that on yesterday. But I think that they've been really, really successful in making this an issue that they can talk about on a populist level, and that they can engage a community of people around because of several different things. I mean, I think, one, they've been able to capitalize on a set of events and issues and quote, bad cases that really resonate with a population of people that they care about, and that they've used that also in the context of this incredible infrastructure that's been built, of media infrastructure that includes, the Wall Street Journal, that includes the Washington Times, that also includes this really powerful grassroots base that includes a very conservative, theologically conservative religious base, Christian Broadcasting Network, Sky Angel, all these different components, so that they can drive a message into the public consciousness in a way that it almost seems natural. I remember one morning I woke up, and actually I woke up because I was getting ready to go to church, and I turned on my television. And you know how sometimes your TiVo kind of goes crazy, and it starts to program things that you never intended to program. So my TV pops on, and there was the Coral Ridge Ministries. And it wasn't, a cross didn't come up on the screen, a minister didn't come up on the screen. It was the head of the Coral Ridge Ministries, and the Constitution appeared on the screen. And for half an hour, what he talked about was the Constitution and talked about the courts. And there are all these quotes, and we can talk about some of them later, where we've got very popular conservative leaders, populist leaders, who are talking about this issue in such a way that it drives an opinion of the courts and judicial activism that I think has really shaped the environment, and in turn has shaped what legislators are able to do. They are thinking about the courts and their impact on the composition of the courts and judicial interpretation through the confirmation experience, through the legislative experience, through court stripping, what's in legislation, what's not in legislation, and as that affects the courts. And I think we'll obviously talk about what we have to do, but I think that they've used a populist model to make this a very important issue. And the last thing I'll say on this particular question is that I think part of the proof that's in the pudding on this is the fact that you take my home state, the Commonwealth of Virginia, George Allen versus Jim Webb. George Allen in a very tight race by polling standards right now. And what's one of the issues that he's talking about? Judicial activism. And he's out in the southwestern parts of the state tying it to a set of issues that people care about there and tying this to the issue of judicial activism. So I think that proves that there's some resonance to it. And what conservatives have done is make this part of a bread and butter issue for a large constituency of people.
Thanks. Pam?
Well, I'm really glad to be here also, and it's a kind of odd transition for me. I missed yesterday's panels because I was at the NAACP Legal Defense Fund's annual Civil Rights Lawyers Conference, and there the discussions about these issues and constitutional interpretation are quite different. If you think about that as an audience, their view is that originalism is a tactic, like anything else. And I think we need to recognize that, at least insofar as we're trying to make a difference in the world with what we're doing, originalism, strict textualism, living constitutionalism, although we don't mention the L word anymore, so, adapting the Constitution to changing times. Like, all of those are tools towards getting towards a substantive end. And the conservatives have succeeded in the attack on judicial activism because people don't like some of the results of the law out there. One of the things that's really striking to me is the number of people, for example, on the right, in the popular area, not in the courts, who think that the Kelo decision was judicial activism. Right? They think that was activist judges letting the state take away their house. Well, when you have that kind of action-inaction distinction, it's very hard to combat that. And I think one of the things we have to recognize is, first, we can't do either the me too, we're originalists just like they are. Sometimes we use originalism, sometimes we don't. We can't do the they too, they're judicial activists. Look at the current Supreme Court, which has struck down more federal statutes than any court in modern times, and that's judicial activism. Because these words, like judicial activism and originalism, are just shorthand for people's agreement or disagreement on the substantive issues. And so I think what we have to do is point out to people the ways in which it is important to have courts enforce rights that people care about a lot. The Supreme Court is still living off the capital of Brown against Board of Education, and we need to call them on that. If we ask what is the most transformative, most successful Supreme Court decision of all times, it's Baker against Carr and Reynolds against Sims. So it's nice to be here in Tennessee to talk about that, which is, if you ask the average American what our democracy means, what the Constitution requires with regard to democracy, they're all going to say one man, one vote. It is the most popular thing out there. You can't find it in the text. although the Supreme Court purports to find it in two separate textual provisions, right, Article 1 and the 14th Amendment. You can't find it in originalism. I think that the Frankfurter and Harlan dissents are just devastating on the question of what was the original understanding, but it was the felt need of the time. And I think we have to get across to people what our values are and hope that they'll agree with them. If people don't agree with our values, in the end, neither having the courts enforce them nor claiming they're in the Constitution is going to make any difference. And I guess I take a little bit of comfort from the long-run view of this, which is I think on most of the issues that I care about, that are social and cultural issues, we actually are winning. It's going to take a long time, but ultimately we're winning on those. What worries me tremendously now, and I think this is something where we can get some traction with the public as a whole, is issues of executive power and unaccountable government. And we can push on those issues. Because I think people today, even if they don't care about judicial review generally, can't believe that they could be hauled off by the government and put in jail forever without ever having some neutral fact finder decide whether they've done anything wrong. And I think that's an issue on which we can push for saying one of the reasons we have to have a judiciary, this goes back to the self-enforcement point, is the Constitution in that sense is not self-enforcing, and the tendency of the current administration to push very hard for a Constitution in which there's just Article 2. I mean, you'd think they would recognize that it'd be odd to just have a second article of the Constitution and nothing else. You need to push on that and make it clear that the court matters to people in a way that's going to protect their rights. Because I think that what has happened is a certain group of cultural conservatives thinks the court doesn't protect them at all. And we need to get across the way in which the Constitution and the courts protect them as well as us.
I've got nothing to say after that. Because I pretty much agree with everything that Pam just said. I think we're going to have to recognize that there's a group of people in the populace that may very well be unreachable for us on some of these issues without sacrificing principles that we hold dear. The key for us, I think, is to capture back the middle ground, the people for whom a common sense approach that taps into some very deeply held convictions that I think the vast majority of American people have about fair play, about having independent, impartial arbiters of things like whether you get to be locked up for the rest of your life, the idea that elections should be fair, the idea that people ought to be able to sue their states if the states do terrible things to them. Those are things that I think the popular imagination can be captured on. But otherwise, I think we will lose the debate for the reasons that Pam outlined, which is that people don't think much about originalism or strict construction. They just equate judicial activism with stuff they don't like. And as a practitioner, I'd say that that's at least somewhat compounded just by the everyday experience of people with courts. I go in and out of state and federal courthouses all the time, and the folks you see there who aren't like me getting paid to be there don't look very happy. They're generally there for reasons they don't like, and their interaction with judges tend to be actually quite negative. They're wonderful judges who do address their courtrooms in ways that I think enhance the reputation of the judiciary, but by and large, it's a kind of a peremptory process. The cases are being moved forward very fairly. Very few litigants come away with 100% of what they expect, and if they come away with less than 100%, they think they've been robbed. And I think that's also, that's a problem that we have to take account of when we think about this issue. But to me, again, to echo what Pam said, I think we need to figure out what it is we care about most deeply and communicate that in a way that is much more effective than we have in the past. And I think the two areas we can do that are government accountability and whether you want to call it checks and balances, or this notion of impartial tribunals, but the refereeing function that courts perform in society. We should at least take a moment, though, to pat ourselves on the back about some things. You know, if you dial the clock back 60 years and you think about where we've come on the issues that we care about constitutionally, freedom and equality, the changes are overwhelming. You know, human history is long, and a period of the kind of progress we've seen over the last 5 decades or so, you know, it's rare. It's very rare, maybe even unprecedented. And so when we think about what's going on now, I think you have to think about it in the context of having had a great deal of success on some very, very important issues. And so now it's a question of holding on to those successes and making incremental progress on really the issue of our time, which I think is the creeping authoritarianism of Article 2.
I may have a slight different take on it. I want to go back to something that Marty said yesterday about first-year law students and discussing these issues with first-year law students who want to believe that there is a law out there, and just answering that this is a battle over values doesn't really work. That also applies to more than just first-year law students. It also applies to a lot of the population as a whole who want to believe that what's going on out there is not just judges giving their individual choice. And what the judicial activism attack has done and what the strict constructionism has done has given the other side what appears to be the high ground. That what they do is they apply long, enduring principles regardless of whether the outcome, and it's the squishy liberals on the other side who will do whatever it needs to get the results they want. And I think the attack of hypocrisy is a powerful political attack as well as being an accurate one on the law. I think it should be pointed out that 11 of the last 13 justices of the Supreme Court have been Republican. I think it should be pointed out by taking a look at the affirmative action cases and the property cases and everything else, and when you're engaging in debates like this, that the conservatives are engaging in the exact kind of thing that they say they are not. And that is, and the discrediting of the position that they are trying to take is a very powerful one in terms of changing hearts and minds. Because when you take away this claim that they are engaging in a higher level of judicial decision-making, it takes away this political claim. I don't know how many of you have ever read Henry Miller's Tropic of Capricorn, but there is a great passage in which one of the characters keeps going into bars to talk about Nietzsche and Socrates and how they would deal with the issues of the day. Walk into bars and talk to people about these issues. I do it all the time for a lot of reasons. And it's really interesting because you get the reaction that, yeah, the liberals, they're just trying to reach a result. And then you sort of talk to people and sort of explain to them that they're willing to take decisions that they might not find originally palatable once they understand that the conservatives really are not engaging in any sort of high ground here. But I think
How many drinks does that take?
it takes 2.
And nobody offers you a hemlock during this.
Yeah. Takes 2. But I mean, this battle has got to be won. It's got to be won at all levels. It's got to be done by engagement at every single possible level. But the story that we let them get away with is a terrible story, and it's also the populism part of this too. I mean, if you take a look at where their results are, as we talked about a little bit about yesterday, their results are always helping the powerful and the entrenched. And that's another story that resounds, particularly in the kinds of bars that I go to. And it can influence the debate on these issues.
Well, if I could just add one thing to that, which is about the 11th Amendment, and this goes back to Eddie's point. There's a conference, kind of civil rights conference, a couple of years ago, and one of the people who talked at the conference was Ruth Garrett, who was the plaintiff in Garrett against Board of Regents of the University of Alabama. And she is a middle-class, white Southern woman who worked as a nurse at the University of Alabama hospitals. And when she got cancer, she had a supervisory position, she asked her supervisor to change her schedule so that it would accommodate her chemo. And they refused, and she had to take a demotion in her job, and she brought a lawsuit seeking pay under the Americans with Disabilities Act for the fact that she had been discriminated against because she was disabled. And she lost because of the 11th Amendment. And she came to this conference and she said, you know, before this happened to me, I wouldn't have understood anything about the 11th Amendment, and I wouldn't have thought that I had much in common with the civil rights community. She said, now, this is basically what I do with my free time. Right? And I think getting those stories across to people, that the civil rights movement isn't just about, you know, black people, and it's not just about gay people, and it's not just about feminazis and the like. I mean, I think it's really important to get across to the average person out there the way that the Constitution protects her. Because I do think on a lot of these issues, we have the populist side, but we're not good at you know, if we spend all our time talking about, well, you know, there's the diversity interpretation of the 11th Amendment, and then there's the, you know, and then there's the original jurisdiction notion, and it's the dual atom of sovereignty, and we need to talk about the genius of that. You know, even if you give people 2 drinks, you're gonna lose them.
That might take 5 drinks.
I want to add something to that point. I mean, I spent 8 years on the Senate Judiciary Committee and around hearings and confirmation hearings, and you know, every time, in fact, you know, we had Mrs. Garrett there, and you know, we found it was like a goal of Judiciary Committee staff, and those here in the room who have been there understand this, to find the worst possible witnesses, people who had the worst possible problems, to try and illustrate your problem. And so we bring people there, and we're, you know, in this very insulated environment. We think, great, you know, we can really capture public opinion with it. And I agree with Pam that that's part of the answer, but I think part of the problem is that we do it in very isolated spurts. I mean, it certainly happens when there's a Supreme Court confirmation hearing. You know, all of a sudden we think, okay, the eyes of the country are going to be trained on this issue. Let's try and communicate to people how these issues affect their lives in a very real way. But when it's over, we pull back into our corners, and you don't hear about it for months and months or years and years and years. And I think there has got to be a more sustained, complete public education program that tries to bring people to this issue in a way that connects them to the issue in a way that isn't so technical. And I think also tying to what Bill was saying, I think a critique is important. And certainly there was a period where I could spout out all kinds of stats and facts and how we'd been wronged. But at the same time, as you know, you look at the debate on the war, it's got to be more than just a critique, because the response is, but what are you going to do? How are you going to deal with this issue? So whereas we can say, this is where you've gone wrong, we also have to be able to respond with what I think is both a meta message and then apply that very specifically to the issues that we care about.
I think that's a great setup for our next topic, but I just want to sort of recapitulate and see if I can capture what people are saying here. In terms of why is this important, I think we have two answers. One, as Melody said, this is important because it has become a movement that drives politics. In the last panel was sort of talking about the separation involving politics. The conservatives have been very successful in taking judicial activism and not only attacking it in courtrooms and in the academy with opposing theory, but in making it a political issue that actually helps generate support for them. And so we've got to find a way to have an answer for that, for the issue on that level, that explains to people that actually what courts are doing or what they're supposed to do is to protect them and why it's a legitimate enterprise. In addition to providing judges and lawyers and people who are in more elite kind of arguments with the kinds of theories that are necessary to take on Justice Scalia when, as somebody said, he comes to Vanderbilt Law School and explains why the only possible way to interpret the Constitution is originalism. So I think in terms of audiences, that's an important point. And I think the other thing that I took from why are they successful is sort of 2 things. As Bill said, they have a theory that appears to be quite legitimate. It's strict constructionism. Judges shouldn't make laws. The framers set up these rules, so isn't it logical to apply the rules that they intended to set up as opposed to judges just making them up as they go along? That's a powerful soundbite cloak for what may be a very result-oriented approach, but it makes it sound legitimate. And the other thing is highlighting cases that people care about and doing it in a way that resonates with the people that they're trying to reach. I think, as people said, in the religion area, the abortion area, there have been tremendous successes, and we've been less successful in explaining why what we think courts should do, or even what we think legislatures should do, is something that's going to help ordinary people in their ordinary lives. But I think in the next two questions, what I'd like to do is maybe go a little in depth in the two things that Melody suggested. One is the critique. Is this neutral sounding approach really so neutral sounding, and is it really cabining judges' discretion, or is it more, can it be revealed as a disguise for something that's pretty result-oriented? And maybe we can talk about that and then turn to what I agree is the most important thing, which is, okay, their approach is no good. What's your answer? Do we want to start? I mean, Bill, I know you're the master of the critique of originalism. Maybe we could start that way and come back down.
Well, certainly never underestimate the power of the negative, particularly with groups that like to claim that they're marching under the banner of truth, black and white. We know the white, they are the black. It's throwing a little doubt in that. For example, what you're seeing in Washington right now with some of the scandals there, throwing a little bit of doubt into this belief system that you are the absolute perfect side, and that the other side is the squishy ones, has a major effect, showing that there's nuance. The other side runs against nuance all the time. To show them that there is nuance in their own positions makes them sort of question whether or not nuanced approach are so bad. One of the great things, and this is an individual conversation, this is not something that I think you can do a media campaign on, but federal affirmative action. There isn't an originalist argument in the world that can support the claim that federal affirmative action is unconstitutional. And part of the conservative agenda, of course, is to get rid of affirmative action. So one of the interesting questions when you're debating with an originalist is, how do you deal with that issue? Explain to me, and the answer that I got from Viet Din once when I was debating one was, do you mean you want to overturn Bowling versus Sharp? And I said, of course I don't want to overturn Bowling versus Sharp, but this is your claim, not mine. Try to reconcile what it is that you're doing, and put them on the defensive with respect to the goals that they want and how originalism doesn't get there. And it's a very effective it's a very effective technique in exposing their inconsistencies and their hypocrisies. And I don't think, and again, I agree with Melody, we need a positive vision. But right now, one of the advantages of being the besieged minority, which I think we are, is that the negative critique against the powerful goes a long way. That's what they did to begin with. I mean, where the energy of the right came wasn't from offering its own positive vision. The first energy of the right came from critiquing what they thought to be erroneous dominant left. And I think that's true with all political movements. The original fire and power comes from the attack, not from the positive vision.
Well, I think the power of what Bill has to say was actually exemplified by the most recent Supreme Court nomination hearing. While you did hear from the senators on the right a fair amount about strict constructionism, you didn't hear that from John Roberts. And the reason is simple, which is that if you walk down the road of originalism, there are a series of extremely difficult questions that get posed. Pam brought one up before, which is, how do you reconcile one person, one vote with originalism? Can't be done. How do you reconcile the state sovereign immunity decisions that the conservatives have championed on the court, where the text and the history of the amendment clearly don't support the idea of immunity against suits against states by their own citizens? When I was clerking, that was the year of Pennsylvania versus Union Gas, which was a turning point in the 11th Amendment jurisprudence. And Justice Scalia, openly agonized about this, and he recognized that he faced the problem of what he wanted to do versus what originalism told him he had to do, and he chose what he wanted to do. And Brown versus Board of Education, it's another one. None of these nominees are going to want to get caught up for precisely the reason Bill says, which is the attack is a potent one. And then there's, on top of all this, the irony that I've always liked, which is just that if the framers didn't intend for us to be bound by their intent, then why would we be, if we were true to their intent, why would we be following their intent? It's a, kind of a vicious circle, and one that I've always been fond of. But I think we have to try and shape the debate as a battle between constitutional principle, which is what we stand for, and constitutional convenience, which is what they stand for.
Well, let me just point to two examples of critiques of originalism that I've observed recently that I sort of liked. One actually was, I teach a course on regulation of the political process, and a couple of years ago when I was teaching it at the University of Virginia, Justice Thomas came to town, and I was asked would I let him come in and co-teach my class for a day. And I said, sure. Right, what I set as the class assignment for the day was for him and the students to read his concurrence in a case called Holder against Hall, where he said essentially, courts can't intervene in the political process to decide questions of fair representation because that requires a political theory. The Constitution doesn't give them a political theory, and therefore they would just be imposing their own values. And I said to him, okay, given your concurrence in Holder against Hall, what would you have done on the Supreme Court when Baker against Carr came in front of the Supreme Court, and what would you have done in Reynolds against Sims? And by the end of the hour and a half, he said he believes in one person, one vote. He thinks it's a great thing. He doesn't know how to get there. Right? And he said this in front of a whole room of students, and I think it was really useful for the students to hear that, because that's when they realized that some of what we take today to be our fundamental commitments, constitutional commitments to democratic self-government of the kind we were talking about before, can't be reached under an originalist theory, and even the people who purport to have a radical in the literal sense of the word, originalism. That's going back to the roots and not looking at the shared experience of the past 50 years, don't want to go there. And if they don't want to go there on that, it's really hard to explain why they're not going there on something else isn't also a matter of just their views shaped by their society. Second one is in a case last year called Georgia against Randolph. This is the case in which the Supreme Court held that, basically to make it clear, suppose Eddie and I were married and we have a disagreement and the police are called and the police get there and Eddie says, she's a drunk. And I say, yeah, well, he uses cocaine. And the police say, mind if we go inside and look around? And Eddie says, being a lawyer, no, you can't go in. I know my rights under Schneckloff against Bustamante. I don't consent. I'm no fool. And I say, vengeful harpy that I am, be my guest. And they go in and they find the drugs in his bedroom.
And I say they're hers.
No. At this point, no. This is my case, not yours. And they say, and we are so estranged, we're not sharing a bedroom at this point. So when they find the drugs in his bedroom, they're clearly his. They move to introduce the drugs at this trial. He moves to suppress, and the Supreme Court holds that the Fourth Amendment does not allow the introduction of the drugs against him. And the dissent by the conservatives talks about the original understandings of the Fourth Amendment and consent and everything. And Justice Stevens wrote a really funny, needling little concurrence that if you're really an originalist here, of course you couldn't let the drugs in, because at the time of the framing, women who were married had no rights against their husband, and therefore she couldn't consent if he's standing there and saying you can't let the cops in. So, if you're really going to take originalism seriously and you're going to apply it rigorously, you're going to end up with results that even for those of us who think the Supreme Court got it right in this case by saying you have a Fourth Amendment right not to have this stuff used against you would be a loopy justification. I mean, we would never have gone to the Supreme Court and said, well, the reason that you can't introduce these drugs is because in 1789 she would have had no right to object because women had no rights. Right? And so you're going to have to take into account that women now have rights not because the 19th Amendment gave them the right to let the police into their husband's bedroom, but because a new understanding of the Equal Protection Clause says if men can consent to letting them come in and search their wives' bedrooms, then women can consent to the men, and we have to get into an argument about whether that consent is or isn't consistent with our notions of privacy. And so I think it's really important to point out that no one does originalism in the strict way that conservatives purport to do it, and none of them are even willing to try.
Well, I'm going to quit my job and produce the Pam and Eddie reality. I think going to something Pam just said, in building a long-term movement around these issues, I mean, there are multiple audiences, and we have to think about, as Andy started out, how we're going to communicate to and with multiple audiences. And some of it is about debate and high-level critique, and some of it is about, I think, the last thing that Pam was just talking about in terms of getting people and getting the public to a place where they can better understand what originalism means and what it doesn't mean. I mean, one of the things that I know through some of the research that we've done is that there is a real desire on the behalf of the public and a real fidelity, going back to our last panel, to this idea of the framers. And the reasons why I think on some level originalism really resonates with people. But as we were talking about last night in the bar, the Constitution as a document, how do you take that understanding of the Constitution as a document, and perhaps even we were talking about, you know, the Bible as a document that many people have a great deal of fidelity to, and their understanding that even though they may be faithful to it, they aren't faithful to it word by word by word. I mean, in other words, how do you help people come to a better understanding of what it means without using the living, breathing document terminology to understand that while their fidelity to the concept of the framers may be something worthy, at the same time in 2006, this isn't an applicable theory and one that can sustain itself in the world in which they want to live in.
I just want to underline the point that Pam made, and I think Bill made too, which is the power of a critique is originalism is sold as this is the way we're cabining judges' discretion. The way they aren't activists is because they have this theory that prevents them from substituting their personal predilections. And what's really important with the cases that were just talked about is it makes clear that's not true, because it doesn't provide the answers automatically like a Wayback Machine. You really, even originalism as the originalists practice it requires some discretion, they would say, in figuring out what the principle is that is embodied in the original understanding. But that's once you recognize that it's all about setting the principle, then you can have a principled fight about that. And it's not really about what was in James Madison's head. I just want to add a couple of other examples to the mix. I think the Commerce Clause is a powerful one because so much of the legislation, as someone on the previous panel said, that people take for granted, Social Security, environmental laws, things that have a huge popular basis, would clearly be unconstitutional under the original understanding of the Commerce Clause. And I think it's important to say, you know, if you think of the medical marijuana case, I think only Justice O'Connor sort of went back to the original understanding and said, well, this is how it would be. The other people, the people who were the true originalists, just weren't willing to make that leap. And I think it's another way to get into a debate about what's really going on here. And I would add, we talked about it last night, the Griswold decision and Loving against Virginia is two other very powerful examples that I think most people would say are results that our Constitution should reach, going back to Frank's idea about rightness. And a theory of interpretation that says those are absolutely wrong is going to cause problems for people, I think. Now, maybe we should move on to the problem that Melody posed, which is, okay, their enterprise is wrong. They really have no engine for supplying a limit on judicial discretion. So what's your answer? And I think that there really are two parts. One is, what's your answer? And then how can that answer be talked about in an effective way, you know, outside of rooms like this? Anyone want to?
Let me reference Jack in a conversation not in a bar, but actually on the way over here.
Then it doesn't count.
I mean, Jack was talking about somewhat why he was tying part of his theory to originalism, and part of it is because it is some sense an originalist theory. But Jack's also pointing, you know, talking for Jack is sort of, cut me off if I'm mischaracterizing you, but it gives a legitimacy. The notion of originalism gives a legitimacy that other kinds of discussions do not give. And what you need, and what the right did was quickly capture, patent, and take trademark control over a word that tried to couch what they were doing with with a sense of legitimacy. And in order to be effective, you have to have something that takes that legitimacy back and gives that sort of enduring meaning to it. A living constitution doesn't seem to do that. A living constitution seems to be a moving target. It seems to play into the notion that you're just talking about giving judges an unfettered role to insert their personal preferences in any decision that they need to make. So I think that any kind of response or any kind of position that we give has to have words in it that connote that enduring sort of sense of legitimacy. We toyed around with some last night. One might just simply be the enduring principles of freedom, equality, and democracy that come from the document. And so I was picturing a candidate, a Hannity and Combs kind of thing. On the one side, we want strict constructionists, and on the other side, now we want people who adhere to the enduring principles of freedom, equality, and democracy. I think we do pretty well in that.
Thanks. I was part of that bar conversation. I'd had a few drinks. I liked it too. I was struck during the Roberts hearings by what I think is now going to be the conservative push to appropriate another concept that I think is also tied to this issue of legitimacy. And that concept is the words, the rule of law. That's what John Roberts talked about at the hearings. That's what he talks about out on the hustings as his commitment. He's not talking about originalism or strict construction. I know, Scalia has actually written about how strict construction is a ridiculous phrase. Why should it be strict versus not strict? It should be fair or whatever. But rule of law, I think, is another phrase that has a lot of resonance, and it's, I think, one that we ought to be pushing to appropriate. That we do need to make absolutely clear that we believe there is a difference between law and whether you want to call it politics or legislating or personal preference, any of those, and that there are boundaries on what is okay in interpretation in a system where there is a rule of law, and that originalism matters, text matters, history matters, precedent matters, and that you are not just unbounded. And we're handicapped by the fact that I think, that one reason the conservative critique is stuck is that there's certainly some areas of law which I think the heroes of the progressive movement have deviated from that approach and have been willing to substitute personal preference for the traditional canons of legal interpretation. But anyway, so I guess if I were to add to the themes that Will mentioned, which I subscribe to, I would say that we ought to be trying to claim the rule of law for our own. And I think the area of national security and all the things that are going on with respect to that is an area in which we ought to be trying to do it.
Well, if I think of what the Constitution is supposed to be in a way, a kind of affirmative vision of the Constitution, I think the Constitution is essentially an appeal, in Lincoln's phrase, to the better angels of our nature, that it's about ensuring that we treat other people the way we treat ourselves, and that's what a lot of equal protection is. And there I find, for example, Justice Jackson's description of why equal protection is a good way for judges to decide cases to be really quite powerful, which is and Justice Scalia says the same thing, by the way, in, who was the unfortunate woman before Terry Schiavo? Yeah, Cruzan, where he says that what the Constitution requires us to do is to accept for ourselves and our loved ones what we're going to do to other people. And I think that notion, that sort of, if we're in the bar doing the lumberjack drinking song, it's the Kantian notion of the categorical imperative, or it's the golden rule, or it's for those of us who have a kind of belief in the secular constitutional belief in equality. And I think the Constitution's commitments are to equality. They're to the idea both that we collectively govern ourselves, and that's democracy, and that individually we have the right to make choices about how we're going to govern ourselves, which is things like free exercise and the right to privacy, which more Americans think the right to privacy is in the Constitution than think that any of the rights actually mentioned in the Constitution is in the Constitution. And I think it's important for us to talk about that. And so I think an affirmative guarantee in the Constitution of freedom and equality and autonomy, both for ourselves individually and for ourselves collectively, is a very powerful vision. And, you know, people will sometimes disagree with some of the decisions under that, but I'm prepared to accept those decisions, and I think we should challenge the conservatives in the same way to say, we accept decisions about your autonomy on things we don't like. I accept the Boy Scouts against Dale decision. You have to accept the decisions that give autonomy to people whose values you don't agree with. And I think people can come to understand it's a bargain in which we protect you, we protect me so that you get protected, and we protect you so that I get protected. And I think that kind of mutual obligation is a way of trying to reframe what we talk about.
The only thing that I would add to that, I just believe that as we're going through this process, we need to keep in mind what I said a few minutes ago, that there is a long-standing desire by the public to hook these things to a sense of history. And I think we need to consider that and consider that filter as we're articulating a set of values and kind of a meta message that we want to drive out there, and one that is certainly bounded by, rooted in a rigorous constitutional theory on our side. But I think that sense of history is important to going back to that sense of legitimacy so that people understand it and believe in it, and don't think that we're doing something that's convenient.
Yeah, I agree with that too, and I actually think that that's something that Eddie mentioned earlier is an interesting way, which we also talked about in the bar last night actually, which is, you know, if it's a slogan, maybe it's interpreting the Constitution the way the framers meant it to be interpreted, which is they didn't put phrases like equal protection or cruel and unusual punishment in the document to just codify whatever the rules were in the respective years. They put them in because they were part of a legal tradition in which those broad phrases changed and were given content through a common law process as time went on. And they would have naturally expected that that was going to be the way that those phrases would be interpreted. So actually, Justice Scalia's cruel and unusual punishment methodology, which is sort of, let's see what was allowed in 1791 and then we can decide, is almost certainly not what the framers thought was going to happen. And I think getting that message out, as Melody said, is a very important part of explaining the legitimacy of where we want to go.
Well, and there are parts of the Constitution that are really quite clear and quite definitive. So it's not as if they just lacked, you know, they were just in some sort of bar-induced fog when they wrote it and they had no way of doing this. I mean, when they want to say something happens on January 3rd, they say it happens on January 3rd. You know, when they want to say this is how, you know, this is how old you have to be, they don't say a person of suitable age and discretion in the way, you know, Federal Rule of Civil Procedure 4 does about service of process. They say, you know, you have to be 25 for this and 30 for this and 35 for this. So when they use broad textured phrases, I think you're absolutely right.
One thing I would say about, just thinking back to when I first got involved in these questions, which was, I suppose, the mid-1980s. On the conservative side, there was a very easily identified set of targets. Everybody understood, you know, what the counter-revolution to the Warren Court would mean, whether it was changing the rules of the death penalty or doing away with affirmative action or attacking Roe versus Wade or Miranda, Engel versus Vitale. I mean, there was you know, you could come up with a laundry list of 10 things that they wanted to have accomplished. I think we have a little bit, one reason I think we may have some difficulty talking about the means is that we're not as clear about the ends, in that we know we want to defend certain things that are actually current law, but the agenda for what we want to do affirmatively is something that's very much a work in progress. And I think as we talk about legitimacy, we also need to keep in mind legitimacy towards what?
The last thing that we wanted to talk about, and I'll do it briefly so we have time for questions, is part of the popular movement that Melody referred to is the sort of judge bashing that seems to be on the rise nowadays. And Justice O'Connor, probably more than anyone else, has been very outspoken and emphatic in her belief that it is really something that's destructive to our whole system. And I don't know if there are any things that we want to say about that and how it plays into what we've been talking about.
Yeah, I mean, I completely agree with her, and from the vantage point at which I used to sit and deal with some of these issues, I mean, it completely corroded the entire system and the process, and made it incredibly difficult to have a constructive debate. And I would imagine, and the judges in the room can speak to this, create a space in which judges can do their jobs and do so in a way that we all, I think, deem appropriate. And I believe, and it's consistent with what we've been saying up here, that part of correcting this goes to a full-scale, as I mentioned before, educational movement. I mean, it is about dealing with the media. It is about having a discerning public. It is about school children and an understanding of how our system works and the beauty of our system. Because without that, you just have this war that's flying around everyone, and people start accepting these terms even without understanding them, I think. And the word activist goes before the word judge very naturally, like they just kind of fit together like, hand in glove. So I think it's incredibly important that we start this educational campaign, again, not just at a time where all of a sudden we're looking at judicial confirmations, but in the off years, in the off months at the same time.
Yeah, I actually last week was at the Justice O'Connor conference on independent judiciary. And one thing that came out of that ties into something Eddie said right at the beginning was Kathleen Hall Jamieson has done a series of surveys, and it turns out the more people have had experience with the judicial system, the worse they think of judges. And it's not just defendants, it's jurors, for example. And so one of the things that we have to do is think about very concrete steps that can be taken to give people more of a confidence in the judicial system. And it ranges from things like not locking them in grungy, horrible jury rooms for days on end when they're not going to be called to serve on juries, to explaining to them what the process is like, to public education in the schools. And also, there too, one of the things that came out of the discussions over the 2 days that I thought was really interesting is we have to stop talking about it as the importance of an independent judiciary. Because independence is a concept that has both a kind of very affirmative cast and a negative cast, which is, of course, nobody thinks judges should be afraid of being shot if they decide a case a particular way, or that judges should be paid based on whether they issue warrants or not. Everybody thinks judges should be free from that. But when you talk about independent judiciary, it sounds like they're untethered from anything, that they are free to do what they want. And I think we have to start talking about the importance instead of a fair and an open-minded and an impartial judiciary, so that we talk about the things that we want judges to do rather than using a phrase like independence, which really makes it sound like they declare independence from all of the rest of us and just do whatever they want. And so I think a lot of this is the way you think about the message, that we don't actually want judges most of the time to be independent at all. When they interpret a statute, we don't want them to say, well, if I'd been in the legislature, this is what I would have passed. I'm free from the legislature. We don't want, for example, judges like Justice Parker on the Alabama Supreme Court to say, I read Roper against Simmons. I think it's a stupid decision. I'm declaring myself judicially independent. I took an oath to support the Constitution. I don't have to obey the Supreme Court when they decide this. We don't want judges like Judge Sprizzo in New York saying, yes, it's true that these particular abortion protesters violated an injunction, but they really believe in what they're doing, so I'm just simply going to give them a Rule 41 dismissal, Rule 29 dismissal, and just say, how can we put these sincere people in jail when they're doing what they believe to be right? And then he says, I think there's a right to judicial nullification. Well, if that's what judicial independence means, it's a bad thing. And so I think we have to talk about, judges who follow the law, and that means both the law statutory and the constitutional law, and judges who are fair and open-minded and unbiased. And So I think, here too, just even the terms of the debate play into the other side's hands by giving people this image of judges up there in black robes doing whatever they feel like.
I'm ambivalent on this one. The federal judges leave state judges out of it. They're protected by life tenure. Obviously, as Pam noted, there are criticisms that are just completely beyond the pale and need to be dealt with forcefully. But I'm not enthusiastic about trying to insulate judges from criticism, even sharp criticism. That's part, I guess, my own experience as an attorney. I think there are many wonderful judges. There are many judges who are not wonderful at all and who take their status as Article III judges as an invitation to a certain imperium to which they're not, in my view, entitled. And we live as progressives in a situation where every federal court of appeal almost is dominated by conservatives. The Supreme Court for the foreseeable future is going to be dominated by conservatives. And I don't, I think we've gone through a period of maybe judge worship, and not that the current environment, which I think is filled with lots of fury and not much light, is a good one. But I have some ambivalence about the way we go about trying to be responsible that we need to be critiquing the judiciary, holding the judiciary accountable to the very values Pam described, without undermining the idea of a fair and impartial judiciary, as Pam put it. So while I don't like the kind of food fight that's going on now, I also don't know that the previous balance was struck in a particularly healthy place. So I'm sort of on the fence on this one.
I may be a little more reserved on this than the other members on the panel. One of the interesting things about the right attack, just in culture generally, if you take a look, we haven't mentioned the media in 2 days, so let me screw that up and mention the media. One of the interesting things about media right now is that the right has done such an incredible job of discrediting mainstream media that all truth looks to be simply a product of, it's a basic postmodern attack, that truth belongs to those who have the power. And I was always amused when postmodernism was starting to take its position in law, saying all law is power, and the thought that once we expose that was going to help the powerless. What it would do, it would give a license to those in power to be able to use it the way they wanted to, which is exactly what you saw in Bush versus Gore, and which is exactly what you see in mainstream media and the way issues are covered. The right has said, yeah, if all truth is constructed by those in power, we're in power, we're going to construct the truth the way we want it. The attack on the judiciary is part of that. And it's a part to discredit the institution, to sort of suggest that there is no justice out there beyond that created by those in power. I think we have to be very careful with that. I think we have to be very careful with adding on to this kind of debate. And I would be much more concerned about defending the judiciary. Yes, there is excesses on the judiciary, and Robin's right and others right that we may not like what the Supreme Court's going to look like for the next 15 years, and we'll be very critical of a lot of the decisions that are going to take place there. But I'm a little concerned that in striking down or in attacking what the judiciary is up to, we're buying into this. We're buying into this overall strategy.
I mean, I agree. I mean, just pulling off something for something else I have to do. Here's a quote. Judges are the most serious threat the United States has ever faced, more serious than Al-Qaeda or the Nazi Germany. The Supreme Court has become increasingly hostile to Christianity, and it poses a greater threat to representative government than anything, more than budget deficits, more than terrorist groups. I mean, and that's not casual. That's not 100 people heard it. That's the kind of stuff that's being broadcast to millions and millions and millions of people. And when I talked about my weird Sunday morning TiVo experience, I mean, that's information, that was on ABC, I think, like at 6 a.m. on a Sunday morning. And it wasn't just a conversation from Coral Ridge about, you know, a set of religious issues. It was an attack on the Constitution and the judicial system writ large. And I agree with Bill. I think that is extremely dangerous in terms of, as I said before, the system being able to work in an impartial and fair way. I don't have any problem with a responsible critique of the judiciary, but you know, it rises to that level, and then there's the debate in the legislature and the legislative branch about impeachment based on these kinds of views of judges. I think that that's very, very dangerous.
Or you get, you know, Senator Cornyn, who used to be himself a state Supreme Court justice, so you think he might understand this a little more than the average legislator, saying, well, I can understand why people are shooting judges. It's because of judicial activism. And of course, all, you know, he says this on the floor, all of the judges who have been shot or whose families have been attacked recently are because of demented, disappointed litigants. You know, and he just is making this up. And the idea that, you know, a senator can get up on the floor of Congress and say, I understand it's judicial activism that leads people to get so upset that they go and shoot judges. I think, you know, we live in a really, to go back to Robin's point from earlier, we live in a really degraded politics where that's thought of as something that it's acceptable for a senator to say, and for nobody in his own party to come out and say, this is an outrage. You know, we've gone so far now that even Justice O'Connor, who is a moderate to conservative Republican, has noticed that there are some attacks on the judiciary. You know, it really does have this kind of almost, you know, Dwight Eisenhower noticing Joe McCarthy moment about it. You know, much as I think we are winning a lot of the cultural battles out there in the community, I think we are losing the battle for the kind of politics that we aspire to, in which people have kind of serious debates about what good policy is and what justice requires. And instead, we've been pushed onto this really quite terrible terrain to fight the battles.
On that happy note, questions?
Oh, geez,
I'll
I've
play
chewed my
Phil Donahue. I guess that's a dated reference.
I guess this seems to me, and I'm interested in Professor Marshall's concept of like 1L is grabbing onto, you know, the safety factor of what it is we think this soundbite that the, you know, Professor Friedman was channeling for the Federal Society. And I think to me, the question more is how do we encourage people to be risk takers? Because it's fine and good to say on the intellectual planes that, you know, we want to point out that the originalism, judicial activism, they're just terms to say, you know, whether we're agreeing or disagreeing. I like that idea. But the populace itself, I think, and Ms. Barnes pointed out that, like, a lot of, you know, the fidelity to the Bible. But unfortunately, to me, I think a lot of people adhere to the Bible as it's, they want to think everything is true. And I think that that's still the safety principle of populace. So we can, you know, contest the Federalist Society itself as to how they interpret the Constitution and that their soundbite is very simplistic. But how do we get the populace to want to buy into what the soundbite you guys came up with the freedom, equality, and democracy? Because that's a nuanced, I mean, how do we get people to be risk takers in that concept? Because they're not right now, I don't think.
Well, yeah. I guess if they're looking at it as risk-taking, we've got some trouble right there. I think there's a two-step process. I think one process is to discredit the vision that's being offered on the other side and to point out its internal inconsistencies, to point out the problems with it if applied mechanically. We've talked about both of those things here. One is they don't do it, and second is if they really did do it, it would get rid of a lot of things like one person, one vote that everybody sort of adheres onto. So you got a two-step critique going to what they're doing. And then you suggest, well, what is it that creates a positive vision? If you're in a 1L class, the answer is you got to think about this and try to look at it. And we talked a little bit about John Hart Ely's and Caroline Bruddock's footnote 4 on the idea of a constitution that protects minorities and reinforces democratic representation, those kinds of things. If you're talking on the broader level, I think what you say is, look, what we know that the Constitution stands for. the principles that it represents. And I like the way that somebody on the panel just said this before. I think it was Eddie. What the framers themselves would want us to do is interpret this Constitution in light of the three ideals that it represents. So you can put that into the framers' terms as what they would want to happen, which is the equality, freedom, and democratic values.
Just to tie that in a little bit with something that Robin was saying on the last panel, and that Pam ended with on such a discouraging note, the democracy part of that. I mean, we spent a lot of time, I think, as progressives thinking about and working towards the equality and the freedom ideals. Not that there's not plenty more to be done, but on the democracy front, this issue of accountability really ties into the question of the quality of our politics. One of the reasons we have such a debased politics, in my view, is that once you get in, you can just stay there no matter how bad a legislator you are. And I think one of the reasons the progressives ought to be pushing that part of the triad as hard as we can in a variety of different ways is to try and achieve some of the goals that Robin was laying out in the last panel about enriching our constitutional discussion, not in the courts, but in Congress, which I don't think is going to happen unless you can vote the bums out a lot more easily than you can now.
Thank you. Except when our opponents don't want to be, they portray themselves as the natural party. You know, they're the natural interpretation of the Constitution, the natural order of things. And except when they're criticizing the institutions that are sympathetic to progressive values, whether that be the media or universities, things like that. Now, do we want to be the postmodern? I mean, do we want to go all the way to postmodern, or do we also want to say, when it suits us, you know, there are natural truths out there in the world that, you know, we can pluck out and discover, or like in a lab, observe? Or do we really want to go all the way over to, you know, it's all truth is power all the way down, and so on?
I guess that's, to me, the answer is I don't want to do that. I think that, you know, I think the postmodern critique is a very powerful analysis, and the idea that we all cannot escape our subjective realities and that there is no objective reality out there is a very powerful critique, and intellectually it's hard to completely dismiss. I think a legal system, however, depends upon the idea that there is some sort of there. And I think we have to stand up for that proposition. I think saying that there are three principles out there that we just talked about, if that's the route we want to go, isn't saying that because we're constructing a postmodern structure. It's because we believe that those three principles really guide what the Constitution was all about. I think the step to postmodernism is an incredibly dangerous one.
I'm not a postmodernist. I'm a sort of paleo-liberal. I think there are truths out there, and I think some of them are embodied in the Constitution, some of them are embodied in our history, in what the people before us struggled for that endures today. I have no, you know, there are things, you know, one thing you might want to read, because I read it all the time and I just find it incredibly powerful, is the talk that Learned Hand gave at the big naturalization ceremony in New York in 1943 that ends up getting published as The Spirit of Liberty. And one of the things he says, you know, the spirit of liberty is not too sure it's right. Well, he's correct about that. There are a lot of things where I'm not sure I'm right. But he also says the spirit of liberty understands that even the least should be heard along with the greatest. And I'm sure he's right about that. I mean, I'm not uncertain about that. I'm not uncertain that equality is important. I don't think it's just my subjective view. I mean, I understand in some metaphysical sense, you know, everything is your subjective view. But I think that's just paralyzing. And I think we should be prepared to say there are some things that are right and there are some things that are wrong. Torturing people is wrong. You know? Denying people the right to vote is wrong. And I don't see why we should be ashamed of that. And I think, you know, the thing that holds us back a lot of the time is we recognize there's some complexity and we recognize there are some difficulties. And so we need to buy something the size of a Hummer in order to fit the bumper sticker on, right? They could have their bumper sticker on an Austin Mini, and we need a Hummer for ours. But I don't have any doubt that there are things that are wrong and that there are things that are right, and that it's important for the law to do justice, and I don't think we should apologize for that.
We're all Platonists now.
We're all Platonists now.
Well, you know, we believe in the form, you have to struggle to get there.
I was curious to hear about the study that you mentioned about that Kathleen Hall Jameson conducted regarding the judiciary, because my understanding of political science, public opinion studies of the courts is that the courts, generally speaking, have the highest level of respect among the population when compared to Congress and the presidency, and that perspective from the public, that support from the public, is very resistant to external shocks. So, for example,
her latest survey suggests in the last 4 years there's been a precipitous decline in the respect the courts have in public opinion polls, and that the decline is highest among people who have had experience as jurors or as litigants with the court.
which is directly contrary to the existing studies. I don't know, you know, that then those studies demonstrate that people who have had experience with the judiciary actually have a higher level of respect for the judiciary than those who have not. So that's very curious, and that's a big flip. And so I'm curious as to what the panel thinks about the, obviously, you know, is there a causal connection here between the rhetoric on the right regarding judicial activism and the level of respect for the judiciary? That's question number one. And question number two involves the relationship between these arguments involving regarding activism and the evangelical community, because it seems to me that where these arguments are coming from are directly related to evangelical Christianity and the separation of church and state. You know, among my other, I have Republican friends, and among my other Republican friends who are not evangelical Christians, this is not an issue for them. They have lots of faith in the Supreme Court, et cetera, et cetera. So what about that connection and what can be done there? I think that's a major issue when it comes to judicial legitimacy of the judicial branch and judicial activism, et cetera.
If I can just briefly say something as I understand it about the recent stuff that Kathleen Jameson was doing, she said this is a big change, that previous studies and surveys have all suggested very high confidence in the courts, higher than in virtually any other institution, and that they didn't suggest that people's greater experience with the courts had caused problems, and she was quite surprised in finding this difference. She didn't give, at least either in the short summary or in her oral remarks, she didn't give any hypotheses about why this was.
Is this about across federal and state courts, by the way?
They didn't ask. They didn't ask. And one of the things is there does tend to be a lot of bleed over between the two. That is, people, I don't know how many of you read the recent study in the New York Times, the 3-part Bill Glaberson article called Broken Bench about the justice courts in New York, but it was kind of staggering. And one of the things is many, many people who have an experience with the court, that's the court they have experience with, the court that's doing traffic tickets or the court that's doing misdemeanors, and they come out of that with a really bad experience, and they don't differentiate exactly between that court system. They don't say, well, you know, of course, these people, they don't even have high school diplomas, let alone law degrees or life tenure or any judicial training or the like. So I think that that may be a big problem. Now, on the evangelical point, you know, one of the things that's always seemed odd to me as a kind of sociological thing about liberals is we tend to all want to show our bona fides by attacking something that we actually want, to show that we're principled. I mean, the kind of archetype of this is John Ely saying, I think abortion rights are really important, but I hate Roe against Wade because it's a terrible case. And I think the current version of this is to, you know, is to blame gay people and their desire to get married for the entire attack on the courts, because after all, it's judicial activism there. And I think that does tie in a little bit with the fact that that seems to be the voting issue right now that mobilizes a conservative base against the courts, is if we don't do something right now, you know, our entire family value structure is going to be taken away from us. But I don't know, you know, it's always hard to know what is actually driving the attack, and whether it's that or it's the idea we can't pray in our schools anymore, you know, or it's some other piece of what the Supreme Court's doing. I just don't even know how to tease that out.
Did your study try and measure whether any of the diminishment is actually on the liberal side, that people looked at Bush v. Gore and said, you know, I just don't get it anymore?
I don't think she did that. I do know Nate personally has looked at all of the kind of, he's doing a paper now on backlash. And one of the things he shows is there was very little backlash against the Supreme Court over Bush v. Gore.
On the evangelical one is interesting. The evangelical Christians used to be the strongest body in the United States on separation of church and state. That was their historical, that's their theological foundations. That began to reverse in the 60s when they thought what was going on was a rampant secularism taking over the country, so they felt the siege. And I think a lot of this is legitimate. The evolution debate is an interesting one because to evangelicals they say, look, you are interested in protecting the sensibilities of every single religious person in the country on prayer in the schools, on crosses. The one thing you don't care about is whether our kids get offended by the teaching of evolution. So for them, they see a sort of a disconnect, and they see a law that is not neutral among religion but is affirmatively hostile to their particular point of view. And that requires, first of all, a recognition that those feelings are honest, not to the political leaders, by the way, but at least to a lot of the rank and file. And it requires a real engagement to talk about why the values of separation, which after all come from your roots, are still important today. And that, I think, is a very sophisticated and a very kind of long discussion that needs to happen. But clearly the religion clauses are a major part of where this activism is felt. Prayer in the schools, the football prayer case, I mean, all of those kinds of decisions.
I would just also add to that we shouldn't homogenize the evangelical community.
That's true.
That it's quite diverse, that President Clinton actually captured the support of a large part of the evangelical community. But going back to what Bill said, I mean, back in the late 60s and early 70s, as a particular wing of the community became more politicized, and that politicization also morphed into a growing connection between the political class. What we've seen is an empowerment of a section that includes leadership very heavily tied to the conservative political wing, and kind of a conversation and a bond between those two classes that's driving a lot of this. I mean, you look at Justice Sunday 1, you look at Justice Sunday 2, I mean, that was, and the connection between senators, the charges of separation of church and state that were made by a more prophetic or progressive religious community. And you can see some of the debate there in the religious community starting to heighten about what's appropriate, and also is showing that there's a diversity even in the religious community about what these issues mean and the role of the courts. And I think that kind of conversation certainly will be more helpful and more healthy to the environment as opposed to the one-sided debate that's been ongoing for the last couple of decades now.
Well, if I could just echo one thing that you just said, Melody. I think it's important for those of us who actually are religious to say that our religion is consistent with a view of equality and dignity and fair treatment, and not to cede the idea that religion is inherently conservative. I mean, if you think back to the entire Second Reconstruction is driven by religious leaders who were on our side and whose lineal descendants are largely on most of the issues we care about on our side. And I think we've ceded too much of this idea that God is on their side. Here's another non-postmodern thing. I actually think, at least the God I believe in, doesn't think that it's a really bad, that we need to have a property rights movement and that the lost Constitution needs to be found along with the lost tribes. I mean, I think it's kind of important to make it clear that people of good faith can be liberals. Because if you say to them, there is a contradiction between liberal political beliefs and religious beliefs, you are going to drive people for whom religion is important out of the liberal big tent. And I don't think you have to drive them out of the liberal big tent.
And it's most of the country.
Yeah.
It's most of the country.
Yeah.
Some of what's been said suggests that some of the hostility towards judges is is generalizable to hostility towards the legal system generally, and there it seems to me progressives have kind of a natural advantage, or ought to, if they use it properly, because the most serious problem with the legal system, from the point of view of most people, is that they can't afford it. They can't afford access to it, and increasingly, it's dominated by conservative decision makers who are trying to actually restrict their access even further, and to change the substantive and procedural law so that it will will be the enemy of their claims, and it does seem that the most successful critiques of Alito during his confirmation hearings, I thought, and as well as correct ones, were that he was hostile to the little guy. Every time somebody came up with a claim against the system, a plaintiff or an individual, against the business or the government, the individual almost always lost. And this wasn't just true in Alito's court; it's true in real life generally. So that when conservatives, for example, tell you that the system is being overrun with tort claims, the correct response is the system doesn't take nearly enough tort claims. Most tort claims are dismissed before they ever get to court. Most ordinary people have no way of vindicating their rights. Most ordinary people can't afford a lawyer. Most ordinary people are confronting a system of substantive law which is more and more tilted against them. The Chamber of Commerce is buying state benches full of state judges who are hostile to individual rights and to individual claims. This and not activist judges is the scandal of the system, and it's one which progressives really need to be concerned to repair.
I think what you said is dead on. As someone who represents corporations in court far too often, it's very, very true what you say. I think it creates a lot of heartache. If you just look at the number of filings around the country, the number of tort filings is going down precipitously because tort reform is actually taking effect, and it's going to hit individuals even more than is already the case, the ability of individuals to vindicate themselves against wrongs. We haven't talked much about the issues of individuals versus big business or government versus big business. We've really been talking about government and structure of government much more. But I think when it comes to the sound bites progressives are going to want to develop that are meaningful and will resonate, this issue of access to justice against for private litigants, the little guy, are very, very important, and hopefully will come to the fore more than they have.
This panel talked a lot about the broad public support for the liberal judicial perspective, and I think that's absolutely true. Most people do agree that liberals and conservatives alike agree that there's a general right to privacy and the principle of one man, one vote. Now, how would you sort of balance that with decisions that really have sort of, I think, broad opposition, such as the Kelo case, which I think you guys sort of dismissed the opposition out of hand, but I think a lot of liberals really did think that was wrongly decided. And also the Gonzalez versus Raich case about the medicinal marijuana in California. I mean, those are cases that I think a lot of liberals thought were maybe a little bit wrongly decided. So how would you sort of balance that with the general perspective that the liberal judicial perspective is does have the moral high ground, which obviously, I do believe. But how would you balance that with the cases that a lot of liberals and conservatives alike are opposed to?
Well, whatever those cases were, they weren't judicial activism. They were judicial passivity, right, which is the Supreme Court sees somebody's house being taken away as part of eminent domain in Connecticut and says, go ahead with it. Or the Supreme Court sees, a federal statute democratically passed that says marijuana is never an appropriate drug, and they say that's for the democratic process to decide. So, if we think those cases are wrong, we think they're wrong because of what we think the Constitution should guarantee people. And I actually don't have a super strong feeling about either of those cases as they were in the posture that they went to the Supreme Court. but that's ultimately a discussion about did the court, what does the Constitution command or not? It's not a case of judicial activism. And so to allow conservatives to use those as additional pieces of evidence for why having judges is a bad thing is a very strange notion of what the critique should be like. I mean, you know, that's like saying judges should step in when they agree with us, and they should stay out when they don't agree with us. Well, you know, everybody at some level thinks that's a good thing. I mean, who wants to say, no, actually judges should step in and strike down things I think are really good, and they should stay out and let things that are really bad endure. And so I think, you know, one of the things is that, and this goes back to the discussion of criticizing decisions as opposed to criticizing the idea of the judiciary. And I think we should have very vigorous criticism of decisions, but I think it's important to kind of maintain a separation there that says, you know, courts can get things wrong. That doesn't mean we shouldn't have courts. And so that's the kind of argument I would make with people who think, you know, I mean, obviously, I think Gonzalez against Raich as a policy matter is a terrible idea. I'm not sure that there's something in the Constitution that prevents it. I mean, I think we do have to remember, this goes back to Eddie's point about the difference between law and politics. Constitutional law is a lot of stupid stuff, and it doesn't prevent every stupid thing. And we need to recognize that there's a broad range of places where it's arguments about politics, and the Constitution should leave a lot of those stupid things to the political process to decide.
Sorry, I thought someone was about to speak. This is going to sound kind of like a simplistic question, but I mean, what do you think we do from here? Because there's been sort of bits and pieces of, you know, walking orders, you know, things about going, you know, talking to people in bars, which really shouldn't be underestimated. I think no, I mean, I think that, and yeah. No, but I mean, I think that's symbolic of just the whole notion of, you know, this organization trying to advocate, you know, discourse over these issues, and, you know, where we can put forth our views. But other than that, I mean, it seems, I guess as a law student, I feel overwhelmed by the amount of chaos that sort of surrounds the concept of how do we get the results that we want. And it seems like ultimately it's just going to come down to, you know, getting the judges we want into the appointments. And we can talk about these education campaigns and transforming society and whatnot, but I mean, what ultimately is needed to, you know, get the results we want on different issues? Does it just come down to getting the appointments and getting the right people in office? And if so, I mean, I don't know.
In the early 1980s or the late 1970s, the conservatives looked around and they said, the intellectual climate of this country is hostile to where we want to go. We have an agenda. We want to push it. They didn't get there right away. They built it up. They built it up by Ed Meese's memorandum in the Justice Department talking about where the Constitution should go, how to get there, how appointment of judges was part of it. But they began inserting the debate, and they began affecting the debate with slogans, with concepts, with the whole bit. It didn't happen overnight, but it happened. And I think the lesson from the Federalist Society is that ideas work and ideas matter. And yeah, it's difficult to sort of say we've done anything real today by sitting around and talking about these things. But we have done something real today. And we've done something real today in terms of what can affect. If we go on and we talk about this and we write about this, and we don't just write about it in law review articles that nobody reads, but we write about it in newspaper articles, and when we're talking on TV shows, or when we're talking in the press, or when we're talking in our blogs, we mention these kinds of things, the world will change. And I think, unlike what the conservatives program has, we have the benefit of truth and justice on our side. And I think that's going to help. They have money and corporate interests. We got truth and justice. But it's a long process. It's not going to happen overnight, but it can happen.
Well, Will's absolutely right about all of that, you know, and you need big moments as well. You know, for them, part of that was in writing, you know, Alan Bloom's book, Robert Bork's book, Tempting of America. These things have really seeped into the public consciousness in a deep way. We need our counterparts. And also, when the big teaching moments come, which, you know, in this world, maybe it's the confirmation hearings, maybe there'll be other opportunities as well. I think we have to be much better prepared to communicate our messages in the kind of straightforward, consistent way that the conservatives have been able to do over and over and over again.
Two things. One, which ties into something that Bob Gordon was saying, is one of the things you can do to avoid sort of losing hope in the long process of this is to actually represent people who need representation, to do the kind of work that will make the world the kind of world you want to live in. And that may mean, you know, doing small pro bono cases, it may be doing impact litigation cases, but doing the kind of work at least part of the time. You know, recognize, you know, with my own law students, and I assume this is true of law students almost everywhere, that most of their time is going to be spent representing, for most of them, corporate interests, because that's what pays the loans and that's where the jobs are and the like. But you can always do pro bono work representing people who otherwise can't be represented, and it will change you and it will change them. The second thing, and this ties into something that Bill was saying, is to recognize the history of this. I mean, this is not the first time that we've been down and they've been up, and it takes a long, sustained time to reclaim what has been taken away. I mean, you know, if you look at the time between when, say, the NAACP was founded and when Brown against Board of Education was decided, let alone the Voting Rights Act and the like, it's 60 years. And so you have to take the long view and recognize that you're part of a process, in that you're not alone in that process. But it's part of a long-term process of changing people's minds and changing people's values, and it's not going to be done overnight, and there isn't a magic bullet, and you can put it on the back of a car, but, you know, nothing on the back of a car except, you know, if you can read this, you're too close, has any immediate effect on people. So I would say do some good work out there in the world and read some history of the civil rights movement or the women's rights movement or the environmental movement to give you a sense that, you know, it takes a while, but ultimately truth and justice do prevail.
And I'll just say, picking up on Pam's point, because I was thinking about it when she said it, the we are not alone piece of that. I mean, I've seen a mapping of the conservative movement, which, you know, love it, hate it, it is awesome. It is a phenomenal thing to see, and it includes financial interests, media interests, legal societies, litigation organizations, think tanks, research organizations, you know, on and on and on, you know, commercial, private, not-for-profit. And it's like building a house. I mean, somebody comes with the drywall, somebody comes with the gas, somebody comes with the sewage, someone comes with the water. You know, it's about putting together a movement, and ACS certainly has a critical role that it is playing and will continue to play in that movement, but it is in combination with a big picture of organizations that have to work in coordination to move us toward where we want to be over the long term. So this is an important part of that, and, you know, we are not alone as we try and do that.
I would echo what Bill said. I've been working on these issues for 25 years, and the power of, you can see the power of ideas in the way that debate has shifted to the right. I mean, it's quite startling. You can look at the makeup of the court. You can look at arguments that people make in lower courts. There has been effected a dramatic change, and there's no reason in the world why things can't change back. We just have to be as focused on it as they were. And I think, you know, in more concrete terms, I'd say two things. I would add to what Pam said. As lawyers, we often are focused on the courts, but as several people have said today, the political process is really important, and being engaged in the political process, in working for candidates or becoming candidates, and probably more outside Washington than in Washington, is a really important part of changing the way these issues are debated. And I think part of ACS's plan is, out of this day is going to come some written materials, which hopefully will provide more concrete grist for bar conversations and others. And I don't know, Lisa, maybe there'll be a fund for all ACS law students to go to bars once a week to sort of talk about this. Anyway, I think our time is up. I want to thank our panel very much. And thank you.